Okay, so we're back. The next thing we're going to talk about is standing. So, standing is a big, big term in environmental law, or at least in the origins of environmental lawsuits. So, standing in the courts means the legal right of a person or organization to sue someone. So, if I'm sitting here in Illinois and I find out that there is a chemical manufacturer in New Jersey who's dumping chemicals into the Atlantic Ocean, I can't sue. I don't have the legal right to sue that person to stop, or that company to stop doing what they're doing. Okay, so that is what standing is, the legal right of a person or organization to sue, and it requires some sort of injury. So our Constitution, Article 3, gives the our judiciary its powers, right? And it limits the power of federal courts to hear what we call cases and controversies. We can't just get advice from them what we think should happen. Okay, so the cases and controversies means that I have to be somehow injured before I can bring a lawsuit. Okay, I have to have a sufficient stake in that case to get a judicial resolution. Some environmental statutes, some of these environmental laws have actually specific provisions for individuals or environmental groups to enforce that statute. They call that like a private attorney general section of the statute. But usually you need some sort of personal stake. You suffered an injury and the conduct caused the injury, and somehow the injury can be either compensated for or prevented by what the court's going to do. Okay, that's a personal stake. Um, so back to our scenic Hudson. Now this is a closer up one, an autumn view of our scenic Hudson case, where we are talking about, this standing issue, right? So the Federal Power Act re- requires that any prospective project is best adapted for improving or developing a waterway, and the standing requirement allows, so this is that private attorney general section on the Federal Power Act, any party that is aggrieved by an order issued by the commission. Okay, so that's the question. Is the issue is this scenic Hudson is a group, a community group that has basically been created to bring this lawsuit. Okay, so the court has to determine what aggrieved means. So they're like, well, do we need economic injury? So they're saying no. The U.S. Supreme Court doesn't require an economic injury for someone to have standing. Um, Only a direct personal interest. So and the statute doesn't require it. Doesn't say economic. It just says aggrieved. So the court reasons that the people who are members of the Scenic Hudson Preservation Coalition, um, they have alleged that they use the trails, they live around the town, they would be affected by noise or disruption of the Storm King Mountain. And then the other party's like, well, if we allow this, then there's going to be future in the future. It's going to happen all the time. We're going to have thousands of future interveners. The court says it doesn't matter. They reject that argument because that's what the statute says. And the statute just says that you have to have an interest and you have to be aggrieved by the order of the Federal Power Commission. So yes, the parties have standing. You don't need a personal economic injury and only some sort of direct personal interest. So this Scenic Hudson decision really sets the stage for allowing environmental groups to bring lawsuits. So here's another one, and this actually I posted last week as an example just of a case for you guys to look at: Sierra Club versus Morton. And here and we're going to talk about this a little later in the class, the APA, whether an organization has standing to sue under the APA. Okay, this one, this was, there was something that was going to happen in the Sequoia National Park, right? I think Disney was going to buy it and make it a nice ski resort. And so the court says, well, no, you don't have standing because you don't claim any injury to your members, Sierra Club. If you allege that your members would be injured by this action, that would have been enough. So Sierra Club was allowed to amend its complaint to allege that. And the happy ending, which is that the Sequoia National Park in California was saved. Take your time. Okay, no, thank you. No, thanks. Okay, so this is Mineral King. That's the area that was saved by the Sierra Club versus Morton lawsuit. Pretty nice. Okay, so that's the happy ending. And then again, we have some of these environmental statutes that have specific sections, but they weren't suing under Clean Air or Clean Water or anything. They were suing under the Administrative Procedures Act, saying that they they hadn't followed the procedures correctly. So that's kind of a failure of a standing case by a group, but in the end, they figured out how to do it. And this case, which I attached to, which is just like one of my favorites, the Cetacean Community versus Bush. And this case was brought not in the name of a citizen group, but in the name of the cetacean community. And I guess the cetaceans is a class of animals, which are where your dolphins, your whales, and porpoises. So kind of your marine mammal-y kind of things. And they tried to bring a class action for an alleged violation of the Endangered Species Act. So what I love about this case, and again, it's posted for you guys to look at, is that it doesn't say, that's crazy, animals could never have the right to sue. They say that if Congress wants animals to have the right to sue, they have to specifically create the right to sue for animals. So they're not saying that Congress couldn't do that if they put that in the statute. So I think that's like such a fun case. I think it's on the quiz. So go and look at it in the module. And just an aside on the Sierra Club. So it's older than the Teddy Roosevelt years. It was in 1892 by John Muir. He founded that. If you guys have ever been to San Francisco, maybe you were in Muir Woods, just out on the other side of the Golden Gate Bridge. And it was just an organization for people to appreciate the natural areas, hiking, and access to these wilderness areas. And then it really morphed to help encouraging the preservation of natural areas. So that little photo of Teddy and John Muir was John Muir saying, like, hey, look at these great areas. Shouldn't we preserve these for people to use now and for future Americans to use? So he really encouraged Teddy to create our national land system and to set aside lands for national parks. The Sierra Club still does it, brought many of the first environmental lawsuits. In 1892, they were trying to reduce the government was trying to reduce Yosemite lands, and they defeated that. Encouraged Benjamin Harrison, he's one of our lesser known presidents, to establish the Sierra Forest Reserve. And he, not only believed that he should be able to enjoy nature, but future generations should support him. So Ansel Adams, I know, like big, great black and white photographer, he was a Sierra Club supporter, and that photo that I had earlier in the lecture of Muir and Teddy Roosevelt, that was an Ansel Adams photograph. And here's another one. So, I mean, he's such a character looking at him, John Muir. He was a crazy old man who loved to be outside. And he looks very, very happy with the mountains behind him, probably the Sierra Nevadas. Okay, so I'm going to pause here. What do I want you to look at now? I want you to look at those cases that Sierra Club and the cetacean community. And after you have a chance to do that, come back and join me for video number 3.